It took the Supreme Court just 10 days to change America as we know it. By rewriting American law as much as any Congress or president in recent memory, the conservative court set off a social and political earthquake. Whether you think that seismic shift was a triumph or a tragedy depends on where you stand on issues like abortion rights, guns, and school prayer. It also hinges on what role you think the Supreme Court should play in our lives. Here to help us explore those issues, we welcome a distinguished bipartisan panel. Ted Olson, conservative legal luminary and former Solicitor General of the United States. Jennifer Rubin, Washington Post columnist and author of How Women Saved America from Donald Trump. And Lawrence Tribe, a liberal legal lion and a preeminent legal scholar at Harvard University. We're grateful to have you all with us. I want to start by focusing on big picture top lines that this most recent term brought into focus. And Ted, I'm going to start with you. Conservatives were euphoric at the end of this term. They rhapsodized about how the rightful role of the court, the constitutional role of the court, has been restored. And as it was put in a Wall Street Journal headline, that the court reclaimed its legitimacy. Now, that's one top line. What's your top line for this term?
I have a hard time talking about the court in that context as reclaiming its legitimacy or responding to people that say that the court has lost its legitimacy. The court is a little bit like an opera every year. They start in October, and the plot unfolds over the course of the year. And then in June, it's like the last act of the opera where there's lots of killing and yelling and arias and rending of clothing and things like that. It's a complicated process that the court goes through. And I think you have to look at the cases individually and talk about the individual decisions and the reason for the individual decisions.
Larry, I'm going to go to you because on the flip side, you had people attacking the fact that this is a runaway court, that it's out of step with the mainstream, with the majority of Americans. And you actually went on the record as saying that you thought it was the most eventful term that you had seen in your lifetime, or that any of us probably would see in ours. What's your top line?
It's a bit like a rather dark opera, I must say. I don't think what matters is when, during the cycle of the court's decisions, the most dramatic ones were delivered. What matters is that when all is said and done, the court seems to have a very clear agenda. It's an agenda that erodes the separation of church and state. It is an agenda that is quite ready to dramatically roll back half a century of women's rights, rights of reproductive freedom. It is a court that is very ready to expand gun rights and to do so in each of these instances in ways that I find it very hard to recognize as reflecting reasoned judgment. It's not really a matter of whether I agree or disagree, although in each of these instances, I'm in strong disagreement. It's that when I look at what the court says, I fail to find reasons. I find bottom lines, but in each case, I cannot avoid the conclusion that the court is saying, we have the votes and we're simply going to do it. There's no caution, no humility, no respect for precedent, no respect for alternative views. I don't think that the court's function is to follow political winds. I certainly don't think it's enough to say that the court is out of step with the majority of the American people on guns and on abortion, though it is. If it were out of step in a direction that protected unpopular rights, or out of step in a direction that perfected representative democracy, protecting voting rights, I would say that's just fine. That's the court's role. It is not the court's role to be another political branch. But instead, it is out of step with fundamental commitments of the American Republic. That is what disturbs me.
Okay, we're going to get more granular on that front in a minute, but I want to get Jennifer into this because, Jennifer, you had written back in April that you were concerned that the court was going to wage war on modern America in terms of social and legal progress. And then after Roe v. Wade was overturned, you amended that by saying you thought that the court was going to initially throw us back to the 60s. And then when the decisions came down, you said the 1860s is where we were landing at this point because of this court. What are your thoughts?
Well, first of all, lovely to be here. Continuing with our dramatic theme, I would say we've devolved into a farce. The Supreme Court has considered itself as an institution to be above politics or beyond politics. That they, in the words of Chief Justice Roberts, they call the balls and strikes. And I think that facade has been stripped away. And it's been stripped away in a few ways. One has been the public rhetoric of the court, which has been political, defensive, nasty at times, very unbecoming and very unusual. I don't recall another court behaving this way. Secondly, the dismissal of precedent that Larry alluded to. One of the things that distinguishes a court from a legislative body is a legislative body can choose on a dime to change policy, to change outlook. But the court is supposed to be an instrument of gradual, predictable lawmaking. And one of the things that keeps it tethered to its correct role as a court rather than a legislature is respect for precedent. And we really saw it in virtually every area that both Ted and Larry mentioned, clear disrespect, almost a contempt for the precedence of the court. And I think in the majority and the minority opinions, you see quite clearly that the majority of the court is taking these departures because they can, because they have the votes. And that, I think, raises considerable questions about the legitimacy of the court. And although I'm not a big fan of polls, I think the Supreme Court and the rest of the political world cannot help but take notice that in polling, the recognition of the support for the Supreme Court, the respect for the Supreme Court has plummeted in not only in recent years, but just in the last year itself. And I do think the court now faces a question of whether its decisions and its actions will be taken as the legitimate decisions of a court acting as a court, or whether they have simply become flunkies for one political position. After all, you would think by the law of averages, occasionally they would come out in ways that disappointed their supporters, but we've not seen that. And I'm sure we'll get into it later. But I think the methodology they have deployed is going to mean we're going to get ever more extreme decisions. I think I'm perhaps more in Larry's camp, but also much more pessimistic about the court's prestige and the ability to withstand calls for structural reform of the court, which could be helpful or could be, frankly, disastrous.
Ted, I want to go back to you because Jennifer just referenced the fact that, in fact, Gallup says that the court's standing at this point, or popularity, is at its lowest level in 50 years. It's at 25%. The question I have for you is, Justice Alito, in writing the majority opinion, said that sort of public opinion shouldn't make a difference. They're doing what they think is right in terms of the Constitution and interpreting the Constitution, and the outside influences or the vagaries of public opinion shouldn't be a factor. What do you think?
Well, I would hope that the vagaries of public opinion, as you put it, should not be a factor. The justices should be deciding according to their training, their conscience, and their previous jurisprudence, the constitutional questions as best they can under the Constitution. The framers of our Constitution created an independent judiciary as a non-political branch. It is supposed to be independent. The court was extremely unpopular during the earlier years of the Roosevelt administration. Uh, it was very unpopular during some of the days of the Warren Court, including with respect to some of the decisions that we're talking of this on the subjects that we're talking about today. If you do not like the decisions, and if you listen to my colleagues here, you are going to feel badly about the court. I'm a defender of the court. I've been on the losing side of a number of decisions from the court. The court decided 50% of its cases this year, 9-1, 9-0, or 8-1. And we're not talking about those cases, but the court, unfortunately, for the court, I guess, has to decide the cases that come to it. And there's the popularity of the court, unfortunately, is going to reflect the criticisms of people who do not like those decisions. That's why I said I like to look at those decisions on an individual basis. As to precedents, the court has overturned precedents hundreds of times in its history. And if you are happy with the Brown versus Board of Education decision that overturned separate but equal, then you think that was a good precedent to overturn. If you do not like, if you like Roe versus Wade and you don't like the decision that undermined Roe versus Wade, then you're going to be angry at the court. I think that we as Americans have to respect the fact that justices make decisions according to their own conscience, and we are going to dislike those decisions many times. It's so important to accord a degree of respect to the court, even if we don't like those decisions.
I'm just going to ask you about one thing, Larry, because it's not a popularity contest. And Ted's talking about the fact that you have to respect even those decisions that you may not necessarily like. But for example, in looking at overturning, taking away a right, Roe v. Wade, Justice Alito talked about the fact that abortion is not mentioned in the Constitution. I want people to understand this. In terms of the 14th Amendment and due process, the 14th Amendment guarantees due process. It doesn't necessarily guarantee the rights that that due process could accord. Is that correct?
It guarantees that people will not be deprived of life, liberty, or property without due process of law.
Right.
It is not simply a list of rights that the Constitution protects. It protects those rights that are fundamental to an individual's life. And I can think of no right more fundamental than bodily integrity. That is what Roe v. Wade protected. It wasn't just abortion. The court also protected the right to have kids. In fact, in the years between Roe v. Wade in 1973 and its reaffirmation in the Casey decision in 1992, there were a number of lower courts that were ready to confront situations in which young girls were forcibly sterilized or forced to have abortions. And the Court of Appeals, in both cases, reversed the lower courts, saying, under Roe v. Wade, you can no more be forced to have an abortion than prevented from having an abortion. It seems to me those were very basic principles. Now, when the Supreme Court says in the Dobbs case that Roe v. Wade was wrong from the start, I keep looking for reasons. What was wrong about it? Well, it was wrong because the Constitution doesn't mention abortion. That's not a good reason. The Ninth Amendment says there are all kinds of rights that are not mentioned that are protected. Ted and I agree that same-sex marriage is among them. The Supreme Court, ever since the 1920s, said the right to decide how to bring up your own children is protected by the Liberty Clause, even though it's not mentioned. So that's not a reason. One looks in vain for a reason why that decision was so wrong that after 50 years, it has to be ripped apart, despite all of the reliance people have had on it.
All right.
That's what bothers me, not just, that I don't like the outcome, but that I think it was arbitrary.
You think it was arbitrary. I just want to get a reaction, Ted, because you were instrumental in establishing the right to same-sex marriage. And according to Justice Thomas, I don't know, I haven't heard that this is necessarily sacrosanct at this point, but Justice Thomas is talking about re-examining or reconsidering issues like contraception and same-sex intimacy. I mean, he's come out and made that statement in his concurrence. So as somebody who did have a hand in bringing about gay marriage as a federal constitutional right, how do you understand why people are upset about the fact that they've taken this right away? So doesn't that open the door potentially to other rights?
I certainly do understand why people can be concerned. I think that has to be put in perspective. The majority opinion in the Dobbs case said nothing that we say in this decision affects those other rights and other circumstances. This is different because abortion does involve the ending or the destruction of a potential human life, and that those cases are different. Justice Thomas said, I agree with what Justice Alito said in that majority opinion, but someday when these other issues come before us, we ought to look at them. But that is one vote or one voice in a concurring opinion. There are 8 justices on the court that did not agree with him and do not agree with that sentiment. I think that we could spend some time talking about the basis for the decision in Roe versus Wade. Is a decision that has many, many characteristics that are very different. It was very unpopular right from the beginning. And if you talk about citizens concerned about what the Supreme Court is doing, that case has been controversial and extremely unpopular, at least in one segment of the population from the very beginning. It has been a sore spot politically and jurisprudentially.
Jennifer, Ted is right. I mean, in the beginning, from the beginning, people argued that Roe was a flawed case, that it was problematic. It, of course, fast forward to the fact that some 61% of Americans approve or agree with having abortion rights in some form in this country. So at this point, people wanted that right to stay. But what is wrong with the court sending that back to the states and saying it's up to you to decide what should be happening?
Well, the court derives legitimacy in large part because its decisions are reasoned, are based on arguments that hold logic, history, and the rest. And the problem that I and many have with Dobbs is that it is entirely lacking in those qualities that make something a judicial opinion. Ted says, well, abortion is different because it's abortion. Well, you could say the same thing about contraception. Contraception is different because it entails one's concern about your life and your reproductive history. So simply saying it's different because it's abortion, I think begs the question. And it assumes that the religious perspective that a fertilized egg suddenly has personhood protections and personhood qualities. I would also say that we have to remember that Roe was then modified by Casey. And for those of us who found the reasoning and the architecture of Roe a little bit odd, Casey really brought it back down to a very traditional 14th Amendment kind of analysis, which demands that for these fundamental rights, you have a compelling state interest. The Casey decision kind of came back to that basic architecture. I also think that there's 2 other serious problems with Dobbs, and this extended to some of the other decisions of the court. I know that we have focused in on the big ticket item, which is Dobbs, but it's true in other contexts. And that is that the court is no longer using our fundamental values and our history in the way that it has been used for forever. Instead, rather than taking a look at a long period of time in which values are crystallized, which history is made, it insists that we go back to the time of the 14th Amendment, which was 1868. And by grounding it in 1868, you are encasing, embalming it in a political dynamic in which women had no rights, certainly homosexuals had no rights, children had no rights. It was a very different America. And the question is, should it go back to the states? That's not what a constitutional democracy with a Bill of Rights and fundamental rights entails. That sort of system says there are some rights, the right to be free of slavery, the right to be free of discrimination, the right to vote, but that such things aren't simply a matter of majority concern, that we have a Supreme Court there to protect rights from the majority. And I think what we are seeing in the aftermath of Dobbs, and it's only going to get worse, is that women's rights, the interests of life, of liberty, of control of one's destiny, of really freedom from physical harm, unnecessary suffering is all put at risk. And those issues, I would suggest, do not simply go back to the states, that these are as fundamental as any right. And I would suggest would never be considered anything less if we were talking about male reproductive freedom or other rights that affect males.
Larry, when Roe was overturned, you went on the record as saying that three presidents, George Herbert Walker Bush, George Bush, and Donald Trump, two of whom won or were elected president without winning the popular vote, and installed or appointed 6 justices, made this decision, and as you said, impacted the lives of tens of millions of women and the rule of law. Now, you hear liberals lamenting what they say is the Republican theft of this court, when the reality is that conservatives made a concerted, diligent effort over decades to fight for the rights that they believed in. And you're at a place where this court may not be popular with some, but this is basically where we are. And I guess my question to you is, what happens in the case of unpopular courts? I mean, you have no recourse at this point.
Jane, let me turn the clock back in our discussion just a moment. This myth that Roe v. Wade was terribly unpopular when it was decided, it was a 7-2 decision. It's only revisionist history that says that from the beginning it was a wild decision. So let me just set that record straight. As to the point of returning the issue to the states, I think that too is a bit of a misnomer, because in the wake of Dobbs, a great many people who I agree waged a very successful agenda-driven campaign, decades long, and have now won. Great many people are saying the next step is going to be a national statute outlawing abortion in every state. What happened to states' rights? They're going to outlaw it in every state because their fundamental belief, and they make it clear when they say that abortion is unique, their fundamental belief is that at what they describe as the moment of conception, we've got a human soul, a new human being. Now, if that's true, the idea that some states can simply allow women and their doctors to extinguish the life of that human being is pretty hard to swallow. The compromise, in other words, of Dobbs is inherently unstable. We're going to move either in the direction of repressing the rights of women nationwide, and that's the direction in which I think it looks like we're moving, or doing something quite radical to undo Dobbs itself. There's no obvious way to do that. Now, those people who celebrate, who say, yes, but look at all the lives we're saving, all these innocent little fetuses. Well, I've had sympathy for the unborn from the very beginning. When I wrote Abortion, the Clash of Absolutes, I criticized the pro-choice movement for basically erasing the fetus as though it was just a bunch of cells. I think we really do have two competing sets of human values here. But when we do, the solution in our Constitution, as I understand it, is not to put it up to the vote of the local majority, but to say, as Abraham Lincoln said, when he said we can't survive as a nation half slave and half free, to say that the ultimate decision must be with the person whose body is involved. And in this case, it happens to be the woman. So I think that although we're spending a lot of time on Dobbs rather than other decisions, the reason is that it raises the most fundamental questions about who we are as a nation. Are we a collection of little majorities that can decide that certain people's bodies are to be used as involuntary vessels? You know, Black women were enslaved in this country, Black men as well, but Black women were not only enslaved, but raped and forced to bear children against their will. What we're talking about is involuntary servitude, forced labor. That's what's involved here. It's amazed me to some extent that not many people talk about the 13th Amendment in this context. But making a woman remain pregnant and give birth is forced labor. It's involuntary servitude. It is also, I think, a serious violation of the Establishment Clause, because it is only religion that can tell you that a human soul arises at the moment of conception.
All right, well, at this point, I do want to switch, and I want to go back to Ted with another case, because there's a disconnect, Ted, between the fact that in taking away the right of abortion rights, the court did it on the heels of making concealed carry a federal constitutional right. So in other words, on one hand, they're sending something back to the states for them to decide. And in the case of the gun case, the gun rights case, they decided, they went in the opposite direction. So again, how do you explain that? Is that not an inconsistency?
I don't think you can compare the abortion cases with the Second Amendment cases. The Second Amendment is a specific right in the Constitution. You may disagree, and I suspect my colleagues do, with the Heller decision that recognized an individual right to bear arms, to keep and bear arms for self-defense. The decision from the Supreme Court this year had to do with the degree to which a weapon could be carried in New York for the purpose of self-defense. New York said, well, just your concern over the neighborhood that you live in, or that you're fearful of your life, isn't enough to justify carrying a weapon as permitted by the Second Amendment for self-defense. You have to show some sort of special need, threats to yourself or something like that. And the court's decision said, well, we don't put that kind of a test in front of individuals who seek to exercise the right to speak or the right to not be put in jail without appropriate right to counsel and so forth.
I do want to ask you one thing, Ted, that Larry referenced, which is that it's pretty clear that if Republicans take back Congress, they will proceed with codifying and passing a national ban on abortion. And the question then becomes, if that national, after it's now gone back to the states, if the national ban came before the Supreme Court, what would they do about that?
With respect to a national ban on abortion, what are you talking about? And I don't mean that as in an argumentative sense. What the proposal that the Democrats in Congress put forth a little while ago was that it would provide a national right to abortion up to the time of delivery of a child. I don't think most people would vote for that. And when people talk about 60% are in favor of some right to abortion, they are not talking about that kind of a right. So how do you draft that statute? If you draft it, that to the extent that it has limitations on abortion after 15 or 20 or 22 or 24 weeks, then I think that there are going to be a lot of people that would support that. When it gets earlier in the life of the unborn child, well, then you get other levels of debate. So I do not think that Republicans in control of Congress are going to pass something that is so restrictive, but there is going to be debate upon when is the appropriate place. And I would think that it might be healthy in this country if Republicans and Democrats got together and have a debate based upon science as to when is the appropriate point at which you want to allow a woman to make that decision, and then at a point at which you suggest that that is not a wise decision and it's a dangerous decision. So, I mean, these are things I don't know the answer to these things. I do think that we should have a legislative debate, hearing the pros and cons and laying out the science for people to talk about.
Larry, since you started the conversation about this national, I think you started talking about the fact that this is something that could happen. Develop that thought. I mean, Republicans would like to have some sort of national ban. I don't know what form that takes, but what do you think?
Well, there is a big debate going on about using the commerce power, the power that Congress has to regulate commercial activity. And although we don't think of it that way, the medical profession is engaged in commerce. And my prediction is that if the Republicans control the House and the Senate and the presidency, so there's no threat of veto, they will enact under the commerce power a very broad ban on pretty much all abortions, because any exceptions, even exceptions for rape and incest and the health and the life of the mother, tend to generate lots of pushback from people who believe that the innocent fetus should not pay the price and that we should actually criminalize all abortions. And that is probably what would happen. And the current court, I'm just making a prediction, would read the Commerce Clause very broadly if a law like that were passed and would uphold it. If, on the other hand, and this is very unlikely, the Democrats were to hold on to the House, take over the Senate, get a big enough majority to overcome the filibuster or make a carve out, and were to pass what the House of Representatives has already attempted to pass, and that is a nationwide codification of Roe v. Wade, not what Ted describes, namely legalizing all abortions to the moment of birth, but basically Roe and Casey, a kind of compromise position. If that were passed by the Congress, my prediction is that the current court would say, we don't think the Commerce Clause goes far enough to sustain that. And Justice Thomas would write an opinion for a majority saying the Congress of the United States does not have the power to codify Roe v. Wade. Heads, we win. Tails, you lose. That's not a very good place to be if what you want is a functioning democracy.
Jennifer, as you know, the meme after Roe was overturned, one of the many memes, became that women have less rights than a gun does. What do you say to women who may have been through this fight 50 years ago, who feel, first of all, really? And second of all, hopeless. What do you say to those women?
We still are a democracy. And the Constitution, for all of its flaws and for all of the controversies we have, gives citizens a myriad of ways to register their disapproval and to change the law or to protect certain groups. One way of doing this, of course, is through now state and local elections. And I think perhaps to their chagrin, Republicans have made banning abortion an issue up and down the ballot. It's as important as when you're voting for a senator who may choose to, as Larry said, ban all abortions, all the way down to the district attorney who has going to have discretion about whether he's going to prosecute women or their doctors. So One way is to exercise political power through the states and through the normal course of elections. The other way is to test the Supreme Court's sort of fickle notion of the Commerce Clause to elect, in this case, Democrats to the House and Senate, and make some change in the filibuster, whereby they would seek to protect that right. And then we'll see what the Supreme Court does. I think there's great uncertainty, but that's certainly a methodology of how we might proceed. And the other is, I think, as Larry pointed out, there are in practice some very important um, issues as we see how Dobbs, if you will, is being applied, or rather how the state bans are being applied in ways that are harmful, that put women's life at risk. And I would go back to some of these bans that use terms, imminent risk of the woman's life, that are hopelessly vague, that have physicians and patients paralyzed, also pharmacists for that matter, and that some of these laws may be subject to legal challenge because of the way the state laws are drafted. But I would say this to many, many people who are frustrated, despaired, and that is that democracy is alive and well in America. We have regular elections. The ability in a variety of ways to reverse this is within our grasp, and it takes political organization and determination. And just as the far right decided that their aim was to eliminate as many abortions as they possibly could, I think the pro-choice side can certainly dedicate itself to the proposition that women's health, lives, emotional life, economic life is worth defending, and pursue all of the democratic means at their disposal to protect those interests.
Ted, I want to go looking a little bit ahead, because there's already been concern articulated about the cases for the next term, which include an affirmative action case, and also there's speculation that what's left of the Voting Rights Act may be basically done away with. What are you, in terms of this court, what are you looking ahead for in terms of what they do in the next term?
I think that one of the most important decisions is going to have to do with the affirmative action case, the admission standards in college. And it's not just college; it's undergraduate, it's high schools and local communities as well. The last time I counted, there were something like 6 or 8 Supreme Court decisions having to do with affirmative action. That is to say, using race as one factor in making an admission decision for a university or college or high school. There are other cases. There are cases involving the Indian Child Welfare Act that involve tribal rights, and that issue is tribal rights and rights of members of the Native American community are very, very important. So this decision, this term coming up, of course, there's cases that haven't been taken yet, so we don't know. But this term coming up is going to be every bit, maybe not every bit, but very much controversial, just like this last one is. And if someone asked me to be a member of the Supreme Court, of course, it won't happen. But I would really wonder whether that's a job that I would ever want, given the fact that every case has to be decided. There has to be a winner and a loser in every case. You're going to have people picketing in front of your house or throwing you out of restaurants, almost no matter what side you're on. Who would want the job?
Okay, well, you did argue, so what is it, 65 cases in front of the court, so maybe that was a better assignment.
If you get paid more that way.
Larry, I want to ask you about an op-ed you wrote, which has to do also with the next term. The revered conservative judge, Michael Ludig, sounded the alarm bells about something called independent legislature theory, that basically it's a blueprint for stealing the 2024 election. And I do think I'm quoting. You wrote this op-ed saying that it does have the power to cut the heart out of our democracy. Tell us why.
First of all, I want to say that Michael Ludig and I are longtime friends, even though, like Ted, he is considerably more conservative than I am. But he and I both agree that the most important thing before the court is not the affirmative action case. There, I think it's important, but also very predictable that 6 justices will say quite clearly, you just can't take race into account in the admissions process of public universities. I think Chief Justice Roberts will write the opinion. He will say, as he did in a prior case, the way to get over race discrimination is to stop discriminating based on race. It'll be a very good slogan. I won't explain right now because we don't really have time what the dissenters are likely to say, but that's all quite predictable. The case where the outcome is not so predictable is called Moore against Harper. It's a case from North Carolina, which both Judge Ludig and I, in writing that each of us has referenced, his has referred to mine has referred to his. We are both convinced that this theory, which I'll now quickly describe, is bogus, but that doesn't mean it has no chance of winning. The theory is that because 2 clauses of the Constitution, the Elections Clause, which deals with how districts are drawn by state legislatures, and the Electors Clause, which deals with how presidential electors are selected by state legislatures, that these clauses give power to state legislatures to do whatever they want, independent of how state courts would hold those legislatures to abide by the constitutions of the states. That is, when state legislatures are exercising their lawmaking function, ordinarily they do so subject to the basic law of the state, which is a constitution. When a state legislature, for example, and in North Carolina, the state legislature actually specifically said, we want the highest court of our state to make sure we comply with the state constitution. When state legislatures do that, in the past, the state Supreme Court has been able to say, wait, you went too far. This is too gerrymandered. Or you're not allowed to simply pick electors. You have to follow the vote of your people. But under the theory that is being put forward in Moore against Harper, the state courts are cut out of the picture. The state constitution is cut out of the picture. State legislature is like a free range body of lawmakers, and they can do whatever they want. And if what they want is to install a president who may have lost the vote in that state, that's fine. Now, if the Supreme Court, and there are 4 justices, including Thomas, Alito, Gorsuch, and Kavanaugh, although Kavanaugh is less certain. Amy Coney Barrett is not certain. But there are 4 justices who've said that's what they think state legislatures can do. Those are probably the 4 who agreed to hear this case. But it takes 5 to tango. It takes 5 to make the rule. And a 5th justice is not all that hard to get in this case. So that's a really important case to watch, and one where the result is not entirely predictable.
I want to ask for a clarification from you, Larry, because people say it all the time. This is politics. We're looking at a court that these are politicians in robes. They're not, it used to be that, again, because of maybe stare decisis and because the court moved, in some cases, there have been courts that were much more radical or activist, but the court moves along, as Jennifer said earlier, with sort of public opinion to sort of ensure the social order and stability. And now you basically said that these decisions are being made because they can be.
Well, let me be clear. I don't think justices are robots. They always bring to the case something of their political philosophy about how the Constitution should be interpreted. Law and politics are not sharply distinguishable, although lawyers have methods that are distinctive. But the court is now much more clearly divided along partisan lines, more so than ever. And although, as Ted Olson rightly said, there are a lot of cases where they are overwhelmingly on one side or the other. There are a lot of 9-0 decisions. And some of those are tough cases, but they're not the politically explosive ones. The ones about guns, abortion, affirmative action, voting rights, those are cases where it is becoming sadly easy to predict where justices will come out. Not because they're corrupt, but because they have come into these positions with well-honed agendas. And so when they go through the kabuki ritual of the confirmation hearings, that doesn't tell us very much. Anybody who listened to Amy Coney Barrett or Neil Gorsuch or Brett Kavanaugh say that, of course, Roe v. Wade is a precedent of the court and Casey is a precedent on precedent, would have yawned and said, yeah, what are you telling me? They're not lying. Those are precedents. They didn't tell us, nor could they, nor should they, what it would take to get them to overrule those precedents. Those of us who studied their past had no doubt that President Trump knew what he was doing when he said, I'm only going to put justices on the court who are going to vote to overrule Roe v. Wade. And sure enough, they did. A lot of this isn't rocket science. A lot of it is not so hard to predict if you just look carefully at what these excellent lawyers have said and done in their past.
Jennifer, we are, believe it or not, almost out of time. And I want to ask you one final question, which is not an easy one, which has to do with the proverbial magic wand. If you could make a change in terms of, we hear a lot about court reform and adding judges, subtracting judges, changing terms to 18-year terms, not having them be life appointments. Can we ever expect that the court will be more compatible with a more moderate way of approaching some of these issues that'll be take into account? The name of this show is Common Ground, where you can have more of a consensus kind of situation. If we were going in that direction, and here's the question, what would facilitate that?
I don't think the goal is moderation per se, or even consensus, frankly. Those may be political goals, but strictly speaking, they're not legal goals, not constitutional goals. I think we are in need of a revision because the nature of the court has changed. Larry is right. Justices now come in with a very defined, very specific agenda. And one of the most disturbing aspects of this court session was the degree to which the outcome was predetermined and the reasoning to get there was fairly shoddy, to be quite honest. So I don't think that per se moderation. I would like to see, however, a departisanation, if that's a word, depoliticalization of the court, so that each one of these confirmation hearings is not a knockdown, drag down, frankly, charade to conceal what the justice is actually going to do, and that justices have a more mild, minimalist sense of their own effect on the law. One of the things we've talked about is stare decisis. And I think there's a fundamental difference in knowing there's going to be somebody else in your seat in 18 years or 12 years, as it is in thinking you're going to change the law for the next 50 years. And so, although there is a healthy debate about whether it would be needed to come about through a constitutional amendment or through a statute, I tend to agree with one of the items that was not quite a recommendation, but was touted in the Presidential Commission on Supreme Court Reform, which was to go to some kind of term-limited arrangement for the Supreme Court, that though they would have lifetime appointments on the federal bench, their stay, if you will, on the Supreme Court would be limited. And there would be some type of rotation whereby you didn't simply have the luck of the draw that one president of one party would get 4 or 5 nominations and the other side would get 1 or 2. And gosh, that's going to make the difference in terms of constitutional law for forever.
Larry, you did sit on that bipartisan presidential commission, and what do you think in terms of if you could pick a way to reform the court, what would it be?
I would expand the court by 4 justices. That's something that Congress clearly has the power to do. The argument that it would then get bigger and bigger, I think when we examined it in that commission, a number of us, some of whom have spoken publicly about it, others not, have concluded that's really not the concern. The reason it's not the concern is that if the Republicans want to expand the court because they have concluded that the current court, though conservative, is not conservative enough for them, they'll do it anyway. The idea that we should just hold back because if we do it, they'll do it, that's a mistake. Term limits sound great, but they're probably unconstitutional unless you amend the Constitution. And besides, they'd have to get phased in. Our commission concluded it might take 40 years to phase them in. And when you do phase them in, you've got a big problem because even if you set it up so that each president during one term will have 2 appointments, if you've got a Senate of the other party that doesn't want to confirm anybody, and we've seen that with McConnell, it doesn't work. So it turns out to be a great idea that probably can't be implemented. So if I had a magic wand, I would expand the court.
Okay.
And I would not feel terrible if it got expanded yet again.
Okay. Ted, we're going to end with you. Do you have a reform you think would be transcendent, would be life-changing for the court?
Actually, no. We don't need a larger court because we have more people. Both Justice Ginsburg and Justice Breyer and justices of both parties have said 9 is a workable number. We don't always agree, which is everybody knows that. But it doesn't improve the situation if you increase the number on the court. I would think that the expanding the court would just make it very difficult because the president of a party is going to look at the number of people and say, well, the other guys did it. And this is what's been happening with the confirmation process. The other side was mean and evil and tough. And we're going to be mean and evil and tough, and it's become a nasty situation. So I think either party is going to do that. I would stick with what the framers of the Constitution created. It is political in the sense that a president makes an appointment and a Senate engages in a confirmation process. But I don't, it's like what Churchill said about democracy. I don't know of a better system. I would stick with what we have. We'll have a new president. We'll have new justices over time. It averages out. Roosevelt got his way, and other presidents have sort of gotten their way, and some of them have been disappointed. I'd leave it the way it was.
Last question, because we are out of time, Ted, but I have to ask you because we've talked about the fact that you all have respect for one another. You're ideologically different in many ways. You have been on both sides of many issues. And when you were nominated for Solicitor General back in 2001, I know that Larry Tribe wrote to the senators on your behalf and said that you would do an amazing job in that role. Finally, you're also married to a lifelong Democrat for, I think, 20 years or something. So my question to you is, how do you think people can find common ground, Ted?
Well, I do think that your program is a very, very good example of that. You made an effort to get Larry and me and Jennifer, and we have different points of view. We have to be able to talk about these things. We have to be able to listen to one another, and we need to have a great deal more than that. Dialogue is so important when people can curb their temper and curb their anger. Larry Tribe wasn't the only one that testified for or supported me in that confirmation process, which, by the way, turned out to be 51-48. So it wasn't so bipartisan. I think Part of that is because we listen to one another. I have a blurb on one of Larry's recent books. I read his books. I listen to what he has to say, and I read what Jennifer has to say. And I think they accord me the same respect. We have to be able to listen to one another and to respect the good faith of people on the other side of these issues and calm down, and take some of the nasty language out of our political debate.
We are grateful to all of you, your voices, your diversity, and your words of wisdom. And now, as we always do, we're going to wrap up our broadcast on a hopeful note with a silver lining moment. On the last day of the court's term, Judge Ketanji Brown Jackson shattered the concrete ceiling when she was sworn in as an Associate Justice of the Supreme Court. Mired in tumult and division as our nation may be, her historic appointment is a testament to how far America has come. On that note, heartfelt thanks to our all-star panel and to you for joining us. Originally from the other Washington, Connecticut, now from Litchfield, Connecticut. Until we see you back here next time for Common Ground, I'm Jane Whitney. Take care.